Okay, so let me say that today I'm honored and very happy to have here Professor Ugo Panizza, who is Professor of International Economics at the Graduate Institute of International Studies, International and Development Studies in Geneva. He is the Deputy Director of the Institute Center for Finance and Development, and is also Vice President and Fellow of the CEPR of the Fondazione Einaudi, and Editor-in-Chief of International Development. He has worked also at the World Bank and the Inter-American Development Bank in the past, focusing on debt for a long period of his activity and research. And Professor Panizza's research interests indeed include banking, central banking, international finance, sovereign debt, and political economy. He has published very many works in a number of prestigious journals on topics and issues that touch upon international economics and macroeconomics, development economics as well. Yeah, I think that his work has reached not only economists, but also policymakers and scholars in very many disciplines. For instance, the discussion that we are going to have today about odious debt is, involves issues that has to do with the ethical and legal aspects, and not just the economic ones, but the same is with the prevention and the management of that crisis that is at the core of global economic governance, that is of interest for international economists, political scientists as well. He has recently published a contribution on foreign affairs on this. If you are interested in European studies, well, clearly that is at the core of the economic governance in the European Monetary Union. And very recently, Professor Panizza also studied the relationship between the fiscal response to COVID-19 and the debt sustainability in developing countries. And again, this is an issue that is an intersection between international and development studies, international security, if you want, and governance. So for all these reasons, I think is really the lecture is going to give today is going to be appreciated by students and faculty members with very different interests. And so I'm particularly lucky and honored to host him today. We have already scheduled this meeting in spring of this year, but we had to cancel it because it was really one of the first few weeks after the lockdown, and we were not ready yet with going online straight away. He was kind enough to renew our to accept again our renewed invitation to all the lectures, so I'm thankful also for that. So without further ado, I would like to give him the floor, and he will share some slide with us, and probably he can do it directly by sharing the screen. Let me say that at the end of the lecture, we will be a Q&A session as usual. Thank you, Ugo, for being with us today.
Thank you very much, Andrea. Thanks to you all for being here. I was very excited about going to Trento. I've never been to Trento. This is one of these places where you always want to go and then something happens. So I hope next spring to talk about something else.
Sure.
So let me see if I can. You have to allow me screen sharing, Andrea.
Yes. Here we go.
Okay. So I'm gonna share this one, share, and then let me do this to see if it works. You're seeing my slides, right? The big one. Super. So, so as Andrea said, I'll be talking about odious debt, and my wife always tells me that I cannot stay away from econometrics, so there will be one regression at the end, but it will be mostly a non-technical discussion. And this is based on work which I've done with lawyer friends. So it will have a lot of legal discussion for which I'm not very well versed, but I'll do my best. I'll try to tell you what I learned from my friends. So this is about odious debt. So we'll explore a little bit more what I mean by this, if you're not aware of the discussion about odious debt. Before going into it, I'll be talking about a bunch of people in this presentation. So I thought it might be, you can associate people with a face. The people I'll be talking about, which have, be my friends and co-authors are in this picture. So I'm one of them, but one of them is Ricardo Hausmann, who has been my co-author and my boss for many years. The other one is Lee Buchheit, who is probably the most famous sovereign debt lawyer. It's the guy who has restructured most sovereign debt, and then everybody else, going from Iraq to Argentina to Ecuador to whatever. And the other one is Mitu Gulati, with actually this presentation is mostly based on a paper which I wrote with Mitu. So these are, so when you hear about Hausman, Buchheit, and Gulati, these are the people. So I will talk about 5 things. I will start with a brief discussion of doctrine of state succession. So this is very important when we talk about debt. I will then introduce the concept of odious debt, and talking about the legal scholar, which is normally associated with the concept of odious debt, with Alexander Sak, a Russian legal scholar. I will then discuss on whether, when we talk about odious debt, we should focus on an ex ante or an ex post definition of odious debt. And then I will make the point that the doctrine of odious debt so far has not gained much traction, and I will discuss whether we could think about alternative approaches which are more feasible from a legal point of view. And then I will conclude, and I'll put forward a modest proposal. So this is the plan of the talk. So let me start with the doctrine of state succession. So I found this cool T-shirt, which Shakespeare, and there is a passage from the Tempest, a play of Shakespeare, which at some point says, "He that dies pays all debt." And this is basically a very well-established legal concept that, if I die, my children are not forced to inherit my debt. So they will get my estate, but if my estate has negative value, that is, if my liabilities are larger than my assets, my children can just say, I don't want it. This is not the case for public debt, because governments do inherit all the obligations, including debt, incurred by their predecessor. So when a government dies, it doesn't pay all its debt, but the successor government inherits the obligations of this government. And this can lead to unpleasant results, because if a government, perhaps a democratic government, that succeeds a dictatorship, which either stole money or used the money to repress the population, this democratic successor government will inherit the debts contracted by the non-democratic regime that preceded it. I think I will mention this later, but if you want to have a stark example, you have South Africa. You had decades of apartheid, and then you have a democratically elected government, and you have the new president, Nelson Mandela, which needs to decide whether to repay the debts, the international debts, which were incurred to the government that put him in jail for like 25 years, or how long Mandela stayed in Rikers Island jail. And an international law and a strict application of international law would say that Nelson Mandela would have to repay the debts incurred by the apartheid government. And in fact, he did honor these debts. And this is very different from inheritance law that has, as you can see from the Shakespeare T-shirt, or as I mentioned before, my kids are not forced to take my debts. when we think about whether there are exceptions to this doctrine of state succession, there are two early exceptions. One, it also applies to South Africa. After the Boer Wars, Great Britain, so this is one earlier session is called the war debt exception. And after the Boer War, Great Britain said that we'll honor all the debts incurred by the South African Republic, which were contracted prior to the war, but none which was contracted after the war started. In a sense, so Great Britain said, I'm going to inherit all the debts, but not the debt incurred to fight me. So this first early exception is that no obligation to repay war debts incurred by a government to finance hostilities against the government which will eventually succeed. So that was one early exception to the doctrine of state succession. And the other exception, which is also related to a war, is related to the Spanish-American War. And so this is related to Cuba, which was, you know, a colony of Spain, and Spain had incurred debt in its own name, but it had pledged Cuban revenue streams as collateral of these debts. And after the Spanish-American War, the US did not take the responsibility because these were hostile debts. So the first exception is war debt, and the second one is hostile debts. And according to this doctrine, hostile debts are when the proceeds are used for purposes which are harmful to the people, were expected to repay them. So the proceeds, so these debt were used to suppress the Cuban people. They're contracted without the consent of the population, and whoever lent the money knew about this. So this is there is a shift of emphasis here with respect to the war debts view, is that it's no longer the case. So the debt becomes a debt of a regime, and it's no longer the case that any governing power can contract debt that bonds a state. And if a lender knows about it, this is the important thing. If a lender knows about this, it cannot claim us like, well, I had no clue. I thought that these people were in good faith. And so when the regime changed, the lender cannot complain if the money, his credits are not honored. So this was the two early exceptions. But one case which is normally quoted when we talk about the odious debt doctrine is also a case that about Latin America. It goes under the Tinoco Affair. So in 1917, two brothers, the Tinoco brothers, seized power in Costa Rica and established a dictatorship. And during the Tinoco dictatorship, there were certain contracts signed by Costa Rica with a British company. So this had to do with an oil exploration concession. And there was also a loan extended by the Royal Bank of Canada. In 1919, one of the brothers was assassinated and the other one ran away to Paris. And the year after, the Costa Rican Congress passed a law, the law of nullities, which repudiated all of Tinoco's contract. Soon after this, a senior British officer showed up in Costa Rica on a warship to show the British might, try to convince Costa Rica to honor its contract with British subjects. There was a long case. At the end, there was the decision of using an arbitration settlement. At first Congress disagreed and then went on, and so this happened. And the arbiter of this was William Howard Taft, which was the head of the U.S. Supreme Court at that point. So eventually he became president. So a very senior negotiator, which at the end, so Costa Rica said this is a debt which is personal of the Tinoco government, so it's not going to bind the democratic government that succeeded the Tinoco dictatorship. The Brits said, yes, you should honor it. And Taft disagreed with the Costa Rica point of view. So it did not recognize the fact, this sort of underlying idea of the odious debt doctrine, which debt contracted by dictators are debt personal to the dictator and not bind the state. But even though Taft disagreed with the premises of the odious debt doctrine, he basically said that Costa Rica should not pay, should not honor this contract, because basically said these contracts were full of irregularities, and the bank that lent the money knew that the money was going to be stolen by the Tinoco, and therefore, it should not be expected to be paid. So the fact that Costa Rica was allowed not to honor the contract was not based on some idea of odiousness, but was based on the idea that the contract was irregular. And this is something we're going to get back towards the end of this talk. While all these things were happening, a Russian jurist was living in Paris, Alexander Sack, writes a treatise which develops the concept of odious debt. It was written in French, so it was the effects of the transformation of country on their public debts and other financial obligation. So this is, it's a long treatise, but this is the relevant passage which is usually quoted, and it says if a despotic power, so a dictatorial power, contracts a debt not for the needs and for the interests of the country, of the state, but to strengthen its despotic regime, to repress the population, this debt, it's odious for the population and the whole state. And if this debt is odious, there is no obligation of successive regime or successive government to honor it. So that's the formulation of odious debt. So according to Sack, a debt is odious if it meets three conditions. The first condition is that the debt is contracted by a despotic power. So it's a non-democratically elected government. Notice that there is some controversy on this. Some legal expert claims that this is not a necessary condition, that a debt could be odious even if contracted by a democratically elected government. The requirement that the majority of legal scholars think that the fact that the government is non-democratic is a necessary condition, but there is a minority who disagrees with this. The second condition is that the funds do not contribute to the general interest of the state. And the third condition is that the creditors know about this. So 3 conditions for that to be odious: despotic government, which uses money to do things which are not for the general interest of the state, and the people who lend the money know about this. So think about this point. The funds will not contribute to the general interest of the state. Now, this is and assume that a government issues a bond, right? So imagine Italy. Italy is still democratic, luckily. Italy issues a bond for 1 billion euro. Then it spends some money. Some of this money might be wasted or stolen, but some of this money are spent, to run school, to run hospitals, to run universities. So it's when there is sort of this, overall borrowing, it's hard to say whether the money is spent for the benefit of the population or not. You can imagine that even the most repressive regimes, even the apartheid regime in South Africa was building roads, was building bridges, was providing some school, and was providing some health. So how do I apply this second category to this idea that the money did not contribute to the general interest of the state? So in a sense, Sachs' idea of odious debt was sort of an idea of a loan by loan analysis. So I analyze all the loans and I see if these loans contribute to the well-being of the population or not. So maybe if it's a loan to buy guns, and then I use guns to repress the population, this is odious debt. But if it's a loan to buy, I don't know, to build a road, that would not be odious, or a useful bridge. But you realize that this is problematic for 2 reasons. Number one, because most of government borrowing doesn't have a specific activity attached. So again, when Italy issues a bonds, it just issue a bonds to finance the government. It doesn't say I'm issuing a bond to finance education or this or that. And second, even if I were to do this, money would be fungible. Let's suppose that I have, $1 million, and with this $1 million, I would build a road, and I want another $1 million to repress the population. Well, then I could borrow $1 million and say I'm using this to build the road, and use the other $1 million to repress the population. So money, you cannot track what money is used to in a state that does many things at the same time. So more modern interpretation focus on the odious nature of the regime, not on individual loans. So we'd say, the apartheid regime was an odious regime because it did all sorts of nasty things. Maybe it also built roads and some hospital and so on and so forth, but it was a nasty regime. So all the lending to the apartheid regime is odious. And this seems to make sense because money is fungible. So here there are examples. So Zaire under the regime of Mobutu Sese Seko, it borrowed a lot. You can think of of the Marcos government in the Philippines, which with the successor government, which decided to service $28 billion of debt inherited from Marcos. I mentioned before, the Mandela government decided to service apartheid debt, Croatia, Iraq, Guinea, many cases. There are 2 interesting more recent cases. One is the case of the tuna bonds in Mozambique. Basically, there were 2 massive loans sort of negotiated in secret and in part intermediated by Credit Suisse. So there is a legal case going on, which were supposed to build, to finance boats for fishing tuna in Mozambique, and no boat ever showed up. And Mozambique took, basically now is stuck with this debt. And then there is one case which is fantastic. So I suggest everybody should read this book. This is a fantastic book. This guy, John Law, which you can see him with Gerardo DiCaprio, is a guy that finished university, was 22, and he managed to steal $7 billion. So imagine a 22-year-old guy who steals $7 billion. And among this money, he financed the Wolf of Wall Street. So the guy, it's a fantastic thing. With a financial scam, he financed a movie about a financial scam. You know, and he was organizing these parties with Paris Hilton and, you know, all these great people. And he basically, he was connected to the Prime Minister of Malaysia. Part of the $7 billion financed the electoral campaign of the Prime Minister of Malaysia. But at the end, the guy stole the money. And, you know, a lot of people sort of suspected that the guy was stealing the money. But Malaysia took over the debt. So Malaysia, the debt of Malaysia increased by 7 billion because this guy financed the Wolf of Wall Street and other stuff. It's a fantastic book. And so the question is like, should Malaysia responsible for this guy was stealing money? So in the book, there is a fantastic story in which, so he financed the electoral campaign of the Malaysian Prime Minister, but the book also tells the story that was financing the personal expenses of the wife of the Malaysian Prime Minister. And there is this story in which the wife of the Malaysian Prime Minister once entered a Chanel store or a Hermes, I forgot, one of these things. And he pointed a bag and the shop assistant said, "Do you want this bag?" And she said, "No, I want everything except that bag." So that was the, anyway. So there is this discussion, what should we do for this type of debt? Should, you know, should countries be responsible? Should the Mandela government have paid for the debt incurred by the apartheid regime, or it shouldn't? Should Malaysia have taken over the debt incurred by John Law while he was stealing 7 billion? Should Mozambique have taken over the debt incurred to finance the acquisition of tuna fishing boats, which were never bought? So some people say no, and some people say that the way to do it is by establishing an odious debt doctrine, which is based on the writing of Sachs, which says exactly what I said before. If debt is incurred by a repressive and corrupt government, successor government should not be responsible for this debt. And when we think about odious debt doctrine, there are sort of two different views. Well, there are three views. One view is said that there should be, that such a doctrine should not exist. And then among people who think that such a doctrine should exist, there are people who think that we should focus on an ex-ante doctrine of odious debt, and others who think that we should focus on an ex-post doctrine of odious debt. So let me tell you a little bit about this. So what is an ex-post doctrine of odiousness? Well, it's simply that when the democratic government shows up, so when Nelson Mandela becomes president of South Africa, Mandela says, look, the apartheid people were evil people. Everybody knew that they were evil people. And therefore, I will not pay you. And, and the odious debt doctrine protects me from international legal suits, like people suing me for not paying, because, the debt was odious. So there is this ex post declaration of odiousness, and we start from there. Now, there are the main issue with implementing on an ex post declaration of odiousness is that this might kill the market for international debt, because many developing countries are not 100% democratic. They're not 100% dictatorial, but they're not 100% democratic either. They're not perfect democracies. And then if international creditor start thinking, well, if I lend to this country, that there is some probability that the guy who comes after me says this guy was a dictator, while it's not such a clear case, I'll better not lend, and this sort of might destroy the international debt market. There is also the case that Ecuador in 2009 did a debt audit and declared some debt odious, and there are serious problems, and we can discuss this afterwards in the Q&A with the Ecuadorian debt audit. And so if people were to start adopting strategies similar to the one adopted by Ecuador, that the debt market, international debt market, might really suffer. Another way that can be done, which was the strategy implemented by Iraq, was not taking a stance on the odiousness or not. Iraq could have said, the Saddam regime was an odious regime. It didn't take this stance, but it just said, we need to restructure the debt, and let's consider it like a normal debt restructuring. And in that case, there were some legal techniques which were used to facilitate this restructuring, but without using odious debt doctrine. The other possibility is, which is described in a paper published in the American Economic Review by Seema Jayachandran and Michael Kremer. Michael Kremer is the person that won the Nobel Prize in Economics in 2019, is to adopt an ex-ante declaration of odiousness. What is this idea of ex-ante? That in this case is not Nelson Mandela, when he becomes president, that declares the apartheid debt is odious, but during the apartheid regime, somebody declares that the apartheid regime is odious. And you can lend to the apartheid regime if you want, but be aware that we think that this regime is odious, and if the government that will come next will decide not to service their debt, they will have the right to do so, because when you lend to the apartheid regime, you lend knowing that an international institution had declared this regime to be odious. Such ex-ante declaration would protect the working of the international debt market, because it would eliminate this ambiguity that I described before, because you know exactly whether you are lending to an odious regime or not. The problem with the ex-ante doctrine, that it would be hard to agree on who is odious and who is not odious. In the proposal by Jayachandran and Kremer, it would be a decision of something of the UN Security Council, but you can imagine that getting the US, China, and Russia to agree on who is odious when some odious guys are friend of the US and some odious guys are friend of China and some odious guys are friend of Russia. In fact, might even argue that some of them are odious themselves. You know, it would be very hard to get to this thing. So this works well in theory. It's a bit more complicated in practice. If you want to learn more about it, the Center for Global Development, which is a think tank in Washington, D.C., has a very nice discussion on this. It even has a model declaration of odiousness, which is, I put it here. I would not go over it, but it's interesting. So the point that this is this idea of odiousness, of odious debt is a good idea in theory, but it's very hard to apply because it would require an international agreement on who is odious and who is not odious. And, you know, in the current climate, especially, it's hard to think of such international agreement to come by. So, so I'm going to discuss whether something else can be done. So Mito and I have a couple of papers about this. But before that, one of the person I showed you at the beginning with Ricardo Hausmann, we proposed that might be, you know, when countries issue bonds, these bonds have attached a credit rating, which will tell you, which are done by credit rating agencies, like the most famous are Standard & Poor's, Moody's, Fitch. And these credit rating agencies tell you how likely is that a given bond will be repaid. If the rating is AAA, for instance, Germany has a AAA rating, it means that the bond is super safe and is very likely to be repaid. If the bond is rated C, it means that that's a risky bond and it's unlikely to be repaid. And, you know, in the middle, you have all sorts of ratings. So Italy is BBB- or something like that. And so in that piece with Ricardo, we proposed that might be, rather than have this black and white declaration of odiousness, we could have an agency that provides odiousness ratings. So rather than having, together with having a credit rating that tells me about ability and willingness to pay, I would also have a rating that tells me how odious a government is, and have a continuous scales from super odious. So we would put, I don't know, North Korea there, to, you know, completely well managed and democratic. I don't know, you want to put, you never know what to put there. Maybe we'll put Switzerland. I don't know if that's the right one. And then a bunch of countries in between. So you know exactly, and the idea that the degree of odiousness will be considered, if in case there is a default, will be considered by judges in deciding how to enforce this debt. So that's a proposal that I had with Ricardo. And of course, you know, the devil would be in the detail, who should issue this rating? It should be a public agency or a private agency. What should be the methodology, and so on and so forth. Another possibility is to use existing private law. You remember the 3 criteria listed by Sack, which was, you know, the despotic regime, the fact that it did not benefit. So let's go back to the 3 criteria, which are here. Despotic, not contribute to the general interest of the state, and the creditor no. In fact, these 2 criteria, the criteria number 2 and the number 3, are already applicable in private law, in a sense that if I go to a bank and I say, I'm here representing the Graduate Institute of International Development Study, my employer, and the Graduate Institute has given me the right to sign a debt contract with you, to borrow from you. and then I borrow, and then I steal the money. If the bank knows that I was gonna steal the money, number one, and two, that I was not a legal representative of the Graduate Institute, that contract is not enforceable already. And this is in normal, that's why the bank would not lend me the money to start with. So this is already, so two of the three criteria of SAC are already part of normal private law. So this is a sentence of the US Court of Appeal. A party will be denied recovery even on a contract which is valid on its face if it appears that that party has resort to immoral or illegal conduct. So you see, this doesn't even require that I'm a dictatorial party. It's just that I'm doing something illegal. Another principle has to do, I don't know if you ever got an email. In the past, you used to get letters, now you get email that, you know, that the cousin of a Nigerian dictator, you know, has 300 million stuck in a bank account. And, you know, if you help them, you're gonna get half of this 300 million, you know. Now you get it from all sorts of stuff, but at the beginning, they all come from Nigeria. Actually, and the way this scam works, if you reply to them, they tell you, okay, but to get this money, I have to pay a fee of $10,000. So send me the $10,000, and then they tell you, send me another $20,000, and I'm gonna milk you until, you know, until you realize that you're just giving them money. So, so somebody sued the Republic of Nigeria because said I got scammed, and what a court in the US said, look, but you were trying to steal money. You got scammed while you're trying to steal money. So you have no power to sue anybody if you got, you know, screwed while you were trying to do something which is basically illegal. And the third legal principle has to do with agency law. And this is related by what I mentioned before, if in case I'm trying to represent the Graduate Institute. So if the lender is aware that the agent of a third party is acting for personal purposes, the principal is not liable. So a loan will not be enforceable just because it was contracted by a corrupt or dictatorial regime. But if everybody knows that that regime is corrupt, the lender should make an effort, should engage into a lot of due diligence to make sure that the money that the lender is lending is not stolen by the agent. So these are existing legal principles, and in a paper with me too, we say maybe we could create the equivalent of an odious debt doctrine. So what's the reason, the rationale of the ex ante odious debt doctrine is to create a situation in which nobody lends to a despotic regime. And by not lending to the despotic regime, you're basically creating a sanction. This despotic regime is more likely to fall. And so our idea, based on the idea that even in non-democratic countries, there are laws which state that the government should act for the benefit of the population, even if it doesn't. So we could use these domestic legal principles to sort of flag loan contract, that contract, which do not respect the idea that the government is acting for the benefit of the population, and make these irregularities public. So if I were to publish a list of all sort of irregular debt contracts done by a regime, then new lenders would be very careful in engaging with this regime, and at the end we would get a result which is similar to what we would get if an ex-ante odious debt doctrine were to exist. So that's the idea that we explore in the paper, and to make this and the idea is like, but would it be true that exposing the illegality of a debt contract would actually cause problems for the borrowing regime and increase its borrowing cost? And so we have a case study which is again linked to, that's why I showed you a picture of these people, which is again linked to Ricardo Hausmann. So Ricardo is a professor at Harvard, but he's also Venezuelan, and is very much opposed to the current Venezuelan administration of Nicolas Maduro. And so let me tell you the story a little bit. So on May 26, 2017, Hausmann published an op-ed titled Hunger Bonds. And basically this op-ed said, you know, the Venezuelan bonds should not part of the standard emerging market index because whoever lends to Venezuela is financing a regime which is starving its own population. So that's the op-ed that Ricardo happened to publish on May 26, 2017. 3 days earlier, and Ricardo didn't know about this, so we talked with him. He had no clue about this when he published his op-ed. A branch of the bank Goldman Sachs had bought 2.8 billion in face value of bonds issued by the Venezuelan state-owned company PDVSA. So these bonds are 2.8 billion face value, but Goldman Sachs paid much less for that. It paid 31 cents on the dollar. So it paid about 860 million for these bonds. And Goldman Sachs claimed that these were old bonds which were bought by people who had bought them years before from Venezuela. But actually, you know, there is evidence that Goldman bought these bonds directly from the Venezuelan government, because basically in the same day in which Goldman bought these bonds, the international reserves of Venezuela increased by about the same amount of money that were paid for this bond. So people did 2 + 2 together. So Hausmann had published this article, you know, we should stop financing a dictatorial government. At the same time, Goldman makes this massive transaction where he buys bonds by the Venezuelan government at a heavy discount. And so these bonds, which were bought by Goldman Sachs, got the label hunger bonds. And this got a lot of prominence. It went on the press. The Wall Street Journal wrote articles about this. It was tweeted by Marco Rubio. It went on the New York Times. And so the term hunger bond became associated with this specific Venezuelan bond. So these are some of the, and you know, people were protesting in front of the headquarters of Goldman Sachs. So this is my favorite point, Goldman Sachs, Goldman Sachs. Goldman Sachs supports Maduro dictatorship. This was the tweet of Marco Rubio. And two things happened next. So investors started asking, is there something legally problematic about this bond? which apparently was issued without proper authorization by the Venezuelan government. And, and there was a legal discussion with the problem of this bond, which I will not bore you with it now. And also people were scared about some reputational stigma attached to this specific bond, reputational stigma, which was associated to these people protesting in front of the headquarters of Goldman Sachs. And even many broker and dealers stopped trading this bond. And here we did a study, and basically you can see this. This is the standard yield on Venezuelan bonds, and sorry, the standard price of Venezuelan bonds. So they're not worth much because Venezuela was already on the verge of defaults at that point. But a bond worth $1 was trading at about 40 cents. The Anchor bonds, when it showed up in the market, was trading just below a normal Venezuelan bond. But after the publication of Hausmann article, the price collapsed, and it stayed way below the price of similar Venezuelan bonds for a very long time. So it seems that the stigma associated to this article did indeed affect the Venezuelan, the value of this specific bond. We did some econometric articles, so this is this shows that after the article, the Anchor bond article was published, the spread of this bond increased by 650 basis points. And the more people were interested in this bond, so these were Google searches for the term Anchor bonds, the more the spread on this bond would increase. In fact, there was an historical precedent. So this paper, the paper that we wrote, Me Too and Die, which is, it's called the Hausmann-Gorky effect, because there was an historical precedent when Maxim Gorky had written a similar piece in 1906, published in a French journal, basically saying that people should not finance the Russian Tsarist regime. Ne dépense sous bureau, because don't give money to these people, which are oppressor of the Russian people, which are oppressor of bodies and of spirits. And there is a paper by Collet and Osterling, which actually shows that this specific bond, which Gorky was talking about, traded at a discount that is at a higher interest rate vis-a-vis comparable Russian bonds. So these are two interesting cases. In another paper with Me Too, we ask, which is titled Maduro bonds, we ask whether we can generalize this issue, whether we can, whether it's the case that publicizing irregularities of bonds issued by despotic regime could be a way to increase the cost of borrowing for these despotic regimes. And and our story is based on three assumptions: that despotic regimes are more likely to be corrupt. So a friend of ours told you your idea would not work with the Nazis, because the Nazis were evil, but they were also very efficient. So you need people who are evil, but also that are not very efficient. So we're assuming that the despotic regime is more likely to be corrupt, that there is a price penalty associated with a corrupt behavior, and that this price penalty associated with a corrupt behavior, it's higher for despotic regime. So in the Maduro bond paper, we test these assumptions So this is the only equation that I have in the whole presentation, and I'm almost done. And basically, we check the spread, that is the borrowing cost of a country in a given period. We look at whether the spread is lower for democratic countries, whether the spread is higher for more corrupted country, and whether I think this is we measure this as a lack of democracy. So if the spread is higher for countries that lack democracy, whether the spread is higher for countries which are more corrupted, and specifically, this is what we care about, is the interaction between democracy and corruption. That is, if the cost of corruption is specifically high for non-democratic countries. So what we care about is this theta parameter. And that's what we get. We get that the more you control corruption, the lower your spread here is. The more democratic you are, the lower your spread here is. But the problem is when when you have low democracy, low corruption, your spread tends to increase. Another way to see this, when you have countries which are highly democratic, this is this group, corruption doesn't matter. When you have countries which are dictatorships, so the index of democracy is less than 3, corruption, it's very important for your spread. Or you can see this stuff, how the relationship between the spread and corruption, it depends on the level of democracy. So conclusions and a modest proposal. So there is a legal debate on whether a doctrine of odious debt exists, and this doctrine does not exist now. It could come via treaty, but this has not happened, and it's unlikely to happen because it's hard to think that there will be enough powerful country would sign to this this doctrine, or via custom, which again it seemed not to have happened. So while debt relief activists have been campaigning for the creation of such a doctrine, these efforts so far did not pay off. However, since many debt contracts are illegal under domestic law in most jurisdictions, including the US jurisdiction, the US, where most international debt contracts are adjudicated, government could repudiate this contract if they wanted. And the question is why they don't do it. And the standard answer given by Nelson Mandela, given by Malaysia, Nelson Mandela when it took over the apartheid debt, given by Malaysia when it took over the John Law debt, the current discussion in Mozambique, is that if we repudiate this debt, even if it's evil debt, nobody's going to lend to us anymore in the future because we will have a bad reputation in the international debt market. If you look at the data, there is no strong support for this very long run cost of reputation. But what we would like to propose is to propose public registry that make public irregularity in that contract, so that we could crowdsource disapproval of illegal debt, a little bit like Ricardo Hausmann did, a little bit like Maxim Gorky did, but do this in a more systematic way. And those find a way which make issuing debt for non-democratic regime more difficult on the basis of existing law and legal principles without the need of creating an odious debt doctrine, which I find desirable, but so far seems to be very difficult to implement. So I'm gonna stop here. I think I talked too much. So these are a bunch of papers which discuss the issues I talked about in details, and I stop here.
Thank you, Ugo. Thank you very much.